Definition 75-A, number 3. Child custody determination means a judgment, decree, or other order providing for legal custody, physical custody, or visitation with respect to a child. Includes temporary, permanent, initial, and modification. The term does not include an order relating to support or other monetary obligation of an individual. 4. Child custody proceeding means a proceeding in which legal custody, physical custody, or visitation with respect to a child is an issue. So only those 3 things: legal custody, physical custody, or visitation. It includes a proceeding for divorce, separation, neglect, abuse, dependency, guardianship, paternity, termination of parental rights, and protection from DV, in which the issue may appear. The term does not include a proceeding involving juvenile delinquency, PINs, contractual emancipation, or adoption. Commencement means the filing of the first pleading in a proceeding. Person acting as a parent means a person other than a parent who A, has physical custody of the child or had physical custody for a period of 6 consecutive months within 1 year immediately before commencement of the proceeding. So again, has or had physical custody for a period of 6 consecutive months within 1 year immediately before commencement of the proceeding, and has been awarded legal custody by a court or claims a right to legal custody under the law of this state. Physical custody means the care and supervision of a child. State means the U.S. states or any territory or insular possession subject to jurisdiction of the U.S. Warrant means an order issued by a court authorizing law enforcement to take physical custody of a child. And tribe means an Alaska Native village, an Indian tribe recognized by federal law or formally acknowledged by a state. Law enforcement officer means a police officer only, not a peace officer. It means a police officer in Article 75. Then it reminds us that this article does not govern an adoption proceeding or a proceeding pertaining to the authorization of emergency medical care for a child. If a question of jurisdiction or exercise of jurisdiction is raised in a child custody proceeding, the question, upon request of a party, the child or their attorney, must be given priority on the calendar and handled expeditiously. Notice to persons outside the state. Notice must be given in a manner reasonably calculated to actually give notice. If person cannot be served within the state, the court shall require that such person be served in a manner reasonably calculated to give actual notice as follows. A. Personal delivery. B. Any form of mail requesting a receipt. C. On motion as the court directs, including publication if service is impracticable under A or B. Or D. In such manner as prescribed by the law of the state in which the service is made. A service made by mail can be proved by receipt signed by addressee or other evidence of delivery to the addressee. Proof of service may also be in the manner prescribed by the law of the state in which the service is made. Notice is not required for the exercise of jurisdiction with respect to a person who submits to the jurisdiction of the court. (75I) is communication between courts, and this basically says that you can call up another court and find out what the court date is. You don't have to tell the parties about that or keep a record of it. But 2 says that for any other kind of communication, the court may allow the parties to participate. If they're not able to participate, they must be given the opportunity to present facts and legal arguments before a decision on jurisdiction is made. Except as provided with schedules, calendars, records, and similar matters, the record must be made of a communication under this section. The parties must be informed promptly of the communication and granted access to the record.